Just want to let everybody know that we're now live on YouTube. The session can begin in about a minute once we have everybody here. That will take us through the house rules, and then we'll begin with the speaking session once Shehla joins.
Hi, Shehla. Are you here? Hi.
Hi, Gurshabad, Anita here. Maybe we can start if all the panelists are ready.
Perfect,
Ankita,
perfect. Yeah.
can we start off with the house rules, right?
Yes, absolutely. A very good evening to everybody, and good morning and good afternoon to those joining us from different time zones. I'm Ankita, Research Associate at IT for Change. Today's webinar is the second in a series of 3 on sexism and the online publics. The series is being held with the support of Edelgift Foundation and International Development Research Center, Canada. And the webinar for today is titled, How Can We Hold Social Media Accountable for Misogyny? A Feminist Approach to Platform Governance. I would like to start with sharing the house rules with you all. Sneha, can you please change the slide? This session will last 90 minutes. The host will alert, as in we all will alert speakers 1 minute before their time ends. We request all panelists except the speaker to keep their mics off during the presentation. For safety purposes, participants' audios and videos will be disabled throughout the session. Participants will be able to interact with everyone through the chat box and ask questions in the Q&A section. Hate speech of any kind will not be tolerated during the session. Participants making such comments will immediately be removed from the session. The discussion will be recorded and posted on the IT for Change's YouTube channel, and we will live tweet this session at IT for Change. Please feel free to tweet, retweet, and tag us. We are exhilarated and honored to have a range of expert voices with us. The moderator for today's session is Gurshabad Grover, who's a program manager at the Center for Internet Society. The panelists we have with us today, we have Mr. Rakesh Maheshwari, who's a scientist as a scientist G and group coordinator at the Ministry of Electronics and Information Technology, Government of India. Mr. Sanjay Sahay, who's a public speaker on issues of information technology and cybersecurity and an ex-officer of the Indian Police Services. Ms. Nappinai, Supreme Court advocate and the founder of Cyber Sathi. and Ms. Shehla Rashid Shora, who's an activist and a PhD candidate at Jawaharlal Nehru University. We also have a respondent with us, Nandini Chami, who's the Deputy Director at IT for Change. Now, turning to our panelists, I invite Gurshabat to open the discussion, please.
Thanks so much. And thanks to IT for Change for inviting me. It's a pleasure and honor to be moderating this amazing panel. I think perhaps as to set the context for this, IT for Change has a set of amazing papers that I recommend all viewers to check out after this webinar. This specific panel is focused on how platforms have been dealing with gender-based harassment and violence online. It is quite contentious, especially considering how initially there was this gender transformativeness that people expected from online platforms, but what we've sometimes seen is that they emerge as strongholds for the opposite, which is of misogynistic content and gender-based violence and harassment. So in this session, we will take a closer look at how platforms have responded to complaints of misogynistic speech. If you have personally experienced it, I know that some of my friends have even set up WhatsApp groups to help them report content. Platforms are often slow in responding to such user complaints. And in some cases, the community standards do not deal with such content at all. And we'll also take a look at, consequently, we'll also take a look at how they can do better in terms of development and application of these community standards. Then we'll also venture into the possible role the law can play in setting accountability and transparency standards for platform governance. Of course, with a feminist approach being often critical of criminal laws trying to regulate either content because of the fear of trampling of freedom of expression, or setting high standards of compliance for platforms, which may often mean that they, as gatekeepers, try to censor speech. So to set the stage and really understand the scope of the problem, perhaps I'll invite Shehla Rashid first. And so, Shehla, there are, of course, several types of gender-based violence and harassment. And do you think, like as an activist and a researcher, that all of them are covered by the community standards in place by major platforms like Twitter, Facebook, YouTube, ShareChat, TikTok, etc.? And if yes, do you think the problem rather lies with how they are enforced? And of course, on a related note, how responsive and attentive to the needs of women, gender, and sexual minorities are these platforms in both their content policies and processes?
Hi, thank you very much. Good evening, everyone. I think that we've debated this topic to death over the past 5, 6, 7 years, whatever it has been. And I think that while there's two things, of course, there's one is the stated policy of the platform, where the platform says that they put on record things like we find it unacceptable, we will remove this kind of speech, and if you engage in this kind of behavior, then we won't tolerate it, and there'll be zero tolerance for that kind of behavior. And then, of course, comes the question of implementation, which I'll come to slightly later. But when we talk about, when we talk about the stated policy, the content policy of the platform, what is acceptable, what is not acceptable, I think, maybe others think that it's a minor point or whatever, but I think that one of the sort of big questions that needs to be addressed here is if the stated policy and the understanding of hate speech or abuse or unacceptable behavior more generally is very Anglo-centric. And the policies are stated, at least for us in English. I don't know how it works in other countries. And many of the terms, many of the abusive terms, or many of the problematic kinds of words said are often, they often get lost in translation. And oftentimes, and this brings us to the question of implementation, that when we report them, they don't usually, there's no action taken. And I think that the problem is that these platforms are very English-centric, very Anglo-centric. And I think that that's an issue from the perspective of common users. At the same time, there's a lot of focus on images. So if you report images that are, that amount to harassment or that are abusive, etc., that gets addressed rather quickly. But when it comes to, say, abuses in Hindi, for example, and written in an English script, it's apparently very difficult for the platforms to detect that and mark that as hate speech or abuse. Now, in my personal case, I mean, there have been instances when issues have become escalated. So, for example, when such a case of abuse or such a case of harassment became very publicly, it became a huge public issue. There was an outcry, and so then the concerned persons were suspended. But that doesn't happen in every case. I think that there needs to be some kind of mechanism for detecting these other forms of abuse. And when we come to the question of implementation, I think that's a very large question. But some platforms have obviously shown more responsiveness than other platforms. And whereas Twitter is the most notorious of all social media platforms, in the way that they have, in the way that this platform is thought to enable hate speech and enable abuse, Twitter has also been the most responsive. Whereas when we talk about Facebook, and I mean by Facebook, I don't mean the Facebook owned products such as Instagram and WhatsApp, because it's different for each product. I mean Facebook, the website Facebook. It is completely unresponsive, and we don't see any form of engagement, any form of redressal. Like oftentimes there aren't even enough categories to report. There aren't even appropriate categories to report certain kinds of behavior, certain kinds of speech. So I think I'd sort of just, unless you have any follow-up question to ask me, I'd rather let others come in here.
Yes, just a quick follow-up question. I think one, of course, absolutely. I think it's been a long-standing critique of such platforms that community standards are not even available in Indic languages often, and of course, most research in natural language processing is targeting English. So even algorithmic filtering is skipping out on a lot of content. So therefore, like a critical question is, who are these community standards even for if they are not accessible to a large audience? Right. I also wanted to get quickly your thoughts on some of the other efforts that the platforms have been trying. So for example, Twitter has recently enabled giving the users option to who can reply or who the tweet reaches to. Of course, and I think Amber argues in his IT for Change paper that the inundation and deluge of hate can sometimes amount to censorship itself, right? But at the same time, limiting the reach while it's giving more control to the user is often a recourse rather than the first option that one can exercise. So what do you think of these sort of features and the future of?
I honestly don't know how I don't know how men what are the responses that men get on these platforms, but as a woman, I think that I have come to terms, and I'm sure that many other women will agree with this. We have come to terms with the fact that our freedom of speech is qualified. It's not unqualified. Our reach, if we have reach and if we have fame, there will be a flip side to this. We will face abuse. I mean, as we do in real life. It's not like real life is a bed of roses anyway. There are challenges in real public life. In real life, there are challenges, but I just feel that social media is a much more skewed place. I mean, in the real world, in public life, you would not face this kind of abuse. It is just out of question. And so it's a trade-off. It's something that we've come to terms with, that yes, in the real world we'll have to face misogyny. In the online world, we will have to face abuse. We will have to face hate speech. And even I'm aware, and I'm sure that many women who use Twitter actively, they are aware that these options limit their reach and the number of people who can reply or engage. But at the same time, I don't know, it's a price that we are paying just for being women, I guess, that we have to use these filters. I mean, they're very effective, first of all. They are very effective to answer that question. But at the same time, they limit our reach. And I guess that I don't really know. I mean, it's less than ideal, this situation, but it's helpful. It's helpful that we have that option because while I was, sort of mentally preparing for this panel, I was just thinking to myself that, Meena Kandasamy, who is who is an activist and a writer and a poet. She recently had to shut down her account, or she had to make it protected, I think. And I, at one point myself, I actually left Twitter for a month, and I came back only when I had taken enough of a break from it. And there must be many such cases. I mean, and this is censorship. The point that I'm trying to make is this is self-censorship. We are either giving up our social media presence because the abuse just gets too much, or we have to make it protected oftentimes, and that also limits your reach very, very severely. I mean, it just makes anything that you say much less relevant. So yeah, let others come in on that. I mean, all I can say is it's a price we pay.
Thanks so much. And I think we'll sort of come back to you on what the platforms can do better, and perhaps think of innovative approaches.
Sure.
And for now, let's go to a slightly related topic. And so, of course, the kind of speech that we're discussing here is sometimes lawful, sometimes unlawful. I think the range of speech that we're discussing here ranges from like sort of bullying to non-consensual sharing of intimate images or criminal harassment. So I like to go to Rakesh Maheshwari ji, and this is I mean, when we think of a feminist approach to internet governance and platform governance, even the provisions in the Information Technology Act that, let's say, criminalize certain sorts of speech have been criticized by feminists for either, being in this paternalistic category of obscenity and trying to regulate it from that lens, or in fact, there is only one provision in the IT Act that sort of regulates non-consensual sharing of imagery, but that has also been criticized for not being used effectively. And of course, we have content takedown laws, and which actually do not, 69A of the IT Act, for instance, does not apply to most forms of content that we're discussing here. And of course, we have the intermediary liability regime. So Rakesh Maheshwari ji, I like, how would you characterize the state's current approach towards online gender-based violence and harassment? And of course, we'd like to hear your opinion too of what you identify as the lacunae in that, and how they, what needs to be filled.
Yeah, so thank you for giving me an opportunity to be able to express my views. I am from Ministry of Electronics and Information Technology, and to that extent represent in a way Government of India, or maybe what is going on in government. But as far as this particular, I should say, conference is concerned, I am presently here in my individual capacity before I begin. Now, I will like to state, the current problems. Practically, we have to look at it from three perspectives: the people, the government, and the laws, and the platforms itself. So from a people perspective, the platforms, in fact, the internet access, the availability of internet access, the whole mobile ecosystem, the low cost of data, and which is what has enabled, in fact, our ability to connect with anybody at any time with anyone. And that's the great empowerment which internet and the social media platforms have provided. But the fact also remains that maybe because it's with the very recent phenomena of we feeling empowered, that we also feel sometimes dissatisfied with the present system, for whatever reasons. And this is where the platform gives us an opportunity to be able to voice our concerns, to be able to share our concerns, across the globe. Society, for some reason, had always been misogynistic. And that remained true in the physical world. That probably will remain true, at least for some time. I don't know for how long, but that's the fact. And that's the fact which is also, reflecting on the internet as well. Now, coming on the government front, or the legal front, see, the IT Act was last amended in the year 2008. And the intermediaries liability or intermediary due diligence rules were published in the year 2011. You can well understand that when the law was last amended, or these guidelines or these rules were published, in a way, the social media platforms were at its nascent stage. There has been a sea change, and to that extent, the law has not been able to catch up with the evolution of these platforms and the evolution of the technology, and that's a worldwide problem. I mean, it's not that we are only grappling with the problem, but that's a worldwide issue. The Constitution, when it was framed, maybe divided the subjects as a state subject and the central subject, and particularly law and order, for example, was considered as a state subject, and so are many other subjects. But so I mean, till such time the problems were there in the physical world, maybe they were all understandable, and probably issues could have been also resolved. But when things move online, state to state, if there is a change of law or laws are different, for example, online gaming, I mean, though not a related topic for today's discussion, but this is where the problem comes. And there is another problem that we have with the law, is that the most of the laws which are there existing today were meant for the physical world. So when things have gone online, we also need to ensure that we are able to have our laws updated to ensure the nuances of the online world. A single case in March 2015 took the powers from the hands of people and limited it to government and the government agency. Particularly, I mean, the way the whole ecosystem was getting developed, probably it was thought, and it's practically true as well, that attending to a large number of grievances, and because we as ministry, I mean, keep receiving a good number of grievances as well of various kinds, maybe because of understanding issues, maybe because of there are real problems, but the fact also remains that maybe courtesy, I mean, or as a sheer single judgment, we as government or have the ability only to handle the unlawful contents, that too primarily through government or agency, and for rest of the matters, it is practically left onto the platforms to take a call. I now come on the social media front, because that's another front. I mean, now social media, as I said, were non-existent when the laws were or the rules were last written. Today, they are an integral part of the life. Almost everyone who is on the net is also in a way connected to one or more of the social media platforms. The platforms have become powerful, maybe more powerful than the countries themselves. So that's one aspect with respect to the platform. Now, with respect to the content, please understand that these platforms are actually into the business of making money as well. I mean, in addition to whatever they are doing, they are also into the business of making money. And unfortunately, it is the glamour, it is the hate speech, it is the misogynistic content which sells. And business being their motto, whatever standards that they may have, they are not easily willing to remove such contents. Algorithms have been talked about. Algorithms, first of all, cannot be 100% accurate. Algorithms, in a way, empower the social media platform to be able to monitor your contents. And to that extent, algorithms can actually be dangerous as well, because your privacy, your contents, your privacies can be breached, your contents can be watched. And to that extent, while algorithms can help maybe identifying the contents and maybe removing such contents automatically, please also understand that no algorithm is 100% correct, and therefore any false positive or any false negative will actually result into a dissatisfaction. And therefore, what platforms also need to do, and they do, is that they do the content moderation, or beyond a point that they need to involve the human moderation. Now, as soon as I say human moderation, it creates yet another problem, in the sense that after all these, and that's where the earlier speaker also told, that these moderators probably are tuned to, or even the algorithms are tuned to understand from the language perspective. Certain international languages, particularly English and vernacular languages, may not be well understood. One. Two, they are not, I mean, the whole subject becomes a subjective. Whatever policy that you may have, there can always be a subjectivity in the decision. The fact also remains, the moderator is a very dirty job. Day in, day out, they are seeing the similar kind of content and they have to make a choice. Anybody who does the repetitive job cannot be paid a good amount of salary, and therefore, please do not expect something great out of such moderators. And that is where, once again, it leads to dissatisfaction. As far as, I mean, there are people, I mean, who, a lot of people whose complaints we keep receiving that their accounts have been deleted, and vice versa, a good number of
sorry to interrupt you. If you could wrap up in 1 minute, then I'll also get
I'm closing.
The other panelists' opinion.
So yeah, I'm closing. So given this kind of a interaction, or given this kind of a, I should say, variance of expectation by the people, by the government and by the platforms, that this is where, in a way, this is what we need to address. We need to make a balance in all these three, and this is what the intermediary guidelines 2011 attempted to, and the amendment that we are still, the work is in progress, that we are attempting to, is to ensure that we as government are able to make such a balance between the expectations of the users versus the capability of the platforms, without violating the principles of privacy and other, I should say, unlawful things. Thank you.
Thanks so much. And perhaps I wasn't able to elicit the response I wanted on how you see the framing of like certain provisions in the IT Act, which have in fact been criticized by feminists for creating overbroad censorship, and most recently by Anya Kovacs and Vrinda Bhandari in their great paper, which I'll also link to in the chat. But we'll sort of come back to you on how the law can be reformed. I'd like to go to Sanjay Sahay ji and sort of get your thoughts on both these aspects. And I'll also perhaps insert another question, which is about the enforcement of these laws, right? And so do you think that law enforcement agencies are informed enough about the provisions that target such speech? And is the police force equipped to, or is it taking complaints of online gender-based harassment and hate speech seriously when they are approached?
So broadly, we are in a whirlpool, and none of the constituents know where they are and where they intend to go. So social media is a creature which remains unknown. The contours are completely unknown. So we'll start with the role of the state. Now, what role does state look for itself? Or it is a referee into all these 3-4 critical elements which are playing and trying to sort out and create a level of equilibrium. Community standards, I don't think there has ever been a meeting between the government, whether it is the central government or the state governments, with regards to the community standards of any single platform, all the platforms combined. So all our discussion is primarily very, very generic in nature. We don't get into nitty-gritty of it. Even misogyny online or whatever all we have been talking about, that has not even been defined anywhere. And so this is the state where we are. So community standards is created by a private company, whereas we are basically taken care or covered by the state itself. And when we talk about the algorithms or whatever has been put in place, let's be very clear about the fact that this whole thing has been created in a very well orchestrated, pre-calibrated manner. And if you go through this movie called The Social Dilemma, you will realize as to where we are and where they intend to take us. The platform's commitment to any of the things and freedom and privacy which we have been talking about, I think it is less than zero, because some amount of lip service has to be paid to be in business. So if you have to be in business, you have to do the lip service, the CSR, which we have been talking about for quite some time, how much of impact it has really made to the elevation or the social responsibility that the corporates have. Leave aside the IT part of it. So presently, the government has to decide what the community stand. It's the private platform will not decide how they will deal with 130 crore population. It's the law of the land. The country will decide as to what the community standards will be, and these particular private parties or these people, the social media platforms, so they will have to comply to that. Now you will say that it is a business model, and they are there for mercenary gain. So all that if we keep talking about, so this is where we'll end up. The criminal part is one part of the story, and I think 99% of the stuff which happens on the social media, though it is non-criminal, I think it is much more criminal than the criminal part of it. And the way it makes life so miserable, it is understandable. And if people are not able to understand within the government or outside of the government, I think it's very, very difficult to take it any further. Leaving aside the enforcement part, when you come to the enforcement part, if you take the cyber crimes itself, I think we started our first cybercrime police station in the year 2001 in Bangalore in Karnataka. And I think we got our first conviction after 13, 14 or 15 years. And of all the convictions which happened in cyber crimes in this country, I think we would have got some 300, 400 convictions by now since the inception of the Information Technology Act. Those also, there are a large number of convictions which happen under the Indian Penal Code. The issues are very, very simple. That we have to set the standards, whether it is their standard operating procedure, whether it is privacy settings, whether their community standard. So that has to be, I can't call it dictated, but that has to be the law, that has to be the norm. And Information Technology Act, I think, is still around 25, 30 years way off from where we stand today. The very purpose of government and governance is to understand the nitty-gritty of the fast changing the social environment. And today, I think the whole social environment is completely dependent on the social media. So until and unless we define, we dictate, we take it further, we influence and bring enforcement to a level. Now, most of your cyber stalking and bullying and all that, where do you report? Under what you report? What do you get out of it? And then you need a whole enforcement mechanism. Even if Data Protection Act is to come in force, the GDPR itself has failed, which is the gold standard of data. So I'm just going on that line of thinking that if you have a General Data Protection Act in this country, what will be the total quantum of enforcement load on the enforcement machinery of this country after elevating them to a totally different level? You have Facebook Caesar, the content Caesar in the US. You don't have the Facebook content Caesar here. And in variety of means, we get these WhatsApp messages, use it for different purposes, left, right, and center for all sorts of purposes. So this is where we broadly stand. So the role of the state has to be decided in conjunction with all the stakeholders. We have to decide what is good for us, how far we go, in which manner to go. And in the same scenario, there are lots of countries who are doing much better. European Union itself, as a conglomeration of countries, is doing certainly much better. They also have a long way to go. But if we try to bring the parties together and create some sort of an equilibrium, I don't think there is any way we can move forward. So we have to decide our standards. We have to enforce 2008 law, when as good as social media was not there, the rules in 2011, and where we stand in 2021. I think there are two different worlds. Is the difference between, I think, the Stone Age and I think the first industrial revolution. So that is the whole gap. And talking generic stuff, and this has happened and that has happened, I don't think that is going to take us anywhere.
Thanks so much, Sahayji. And I think sort of thanks for shedding light on the law enforcement part of this. What I'm hearing is that there's a lack of capacity to deal with the so many issues that are coming up, but perhaps it's a question of prioritization, whether
see, everything is a matter of prioritization in a resource scarce,
a
resource scarce economy.
Yeah,
in a resource scarce economy and a resource scarce country.
It is exactly about then, right? About
Correct.
what complaints the police is dealing with, whether
correct, and also the capability,
young women's
capability of
social
what
media
quantum you can deal.
Of course.
Correct, and that quantum is based on expertise and using technology.
Yes, of course.
Okay.
I think the point made earlier was how the law can be more responsive to the women's needs rather than like what we're
Yes,
seeing now,
yes.
which is
We are
something
having gender
deployment.
sensitization for last 3 decades, if I'm not wrong.
Yep, yep. So
Correct.
uh, uh, I'll sort of take a slightly related point that Mr. Maheshwari also touched on. And Nappinai ji, if I could ask you, and Maheshwari ji mentioned that in the Shreya Singhal judgment, where of course one part of the judgment said that there is no obligation of online intermediaries and platforms, no legal obligation in that sense to entertain third-party notices, and Maheshwari sees this as like a dilution of user empowerment in that sense. Of course, the critique of that provision was that if users are sending notices to these platforms left, right, and center, then these platforms are more incentivized to take down the content and sort of be on the safe edge rather than risk liability. So apart from, of course, your response on what we've heard so far, Nappinai ji, if I can ask you to sort of shed light on how you see the role of Shreya Singhal and how you see the intermediary liability regime fit into our discussion of user complaints and content moderation.
Thank you for that question. Well, this is a very well-structured panel, I must say, because you're covering from the policy to law enforcement to the legal aspects now, and most importantly, from a victim perspective too. So when we are looking at all of these, and there were two aspects of what Shehla mentioned that I wanted to touch upon too, and it kind of ties in with what Sanjay just mentioned in the last intervention. Oh, Shehla talked about two things. One is about how each one of us as women are very familiar with self-censorship, because that is the best way to survive online. Then she also talked about another very interesting aspect, which is about how do you figure out, how do you file a complaint? She talked about the lack of the correct tag for a complaint to be filed in terms of criminal content online, right? And of course, she also spoke about this aspect about what is the kind of action we can expect from a social media platform. When I tie that in along with what Maheshwari ji and Sanjay ji said, let me give you a slightly different perspective. There are two things I want to touch upon. One is there may be a lot of pessimism that may arise in the minds of a viewer when you just talk about Shreya Singhal and what it did not allow people to do. But what we really need to also focus on is what did it allow for in terms of protection of victims. And two, as Sanjay ji just pointed out, we've been doing gender sensitization for why decades, it could be even centuries or millennia, right? But if there is no variation in the theme, then what is that variation which we can look at? And that's where I think what I would like to share comes into play. And I can tell you that my inputs come from my practical personal experience as a lawyer, not in my personal experience as a social media user. So, we talk always about what cannot be done, what is not working, how is it not working, and why is it not effective. When we also focus on what is working and how can we work better, that level of optimism actually can bring you results. And I always say that I am an extreme optimist, and I think that kind of faith in a system also helped in a way. So this is I'm going to give you a short clip on the anecdote because I want to focus on a few other thoughts over today. My first collaboration with IT for Change was in the wake of my involvement in Prajwala versus Union of India as amicus curiae, where I wrote on a similar aspect, but more in focusing on the freedom of women online, or as Anita very poignantly captured when she requested me to write, the unfreedom of women. And we consciously chose that word and not restrictions on women, because we wanted to focus on how women thought that they had a lot more freedom online. And we therefore ventured forth very boldly, and only to be met with all those issues which Shehla pointed out, and we all know of, right? And how and to what extent misogyny works online. One of the earliest cases of misogyny, in fact, was against Meena Kandaswamy, again, somebody whom Shehla mentioned about also. So anyway, we have grown up assuming and thinking about all these problems offline and now online. And then came Shehla. And then came a government committee which was appointed by the Supreme Court to evaluate some of the technical aspects that were proposed before the court. One of the significant ones of which was what I had suggested, saying everybody is talking about blocking, which becomes a concern in terms of free speech, or in terms of just a takedown, which is too late for the victim, right? Or sometimes action may not happen at all. So we were living, and we continue to live in a world where enforcement is certainly weak. And that is something, if we are really looking forward, that is something we need to strengthen. But otherwise, if the conversation is only going to be about what has to come, there is an assumption that there is nothing today. Whereas we have very strong laws, be it substantive or procedural. It is not for want of laws that misogyny or hate speech continues. It's for want of better implementation online that we are actually struggling in terms of how it is functioning. And that implementation, we are not pointing a hand only at law enforcement or judiciary. It is across the board. And to a large extent, there is a lot of struggle that every single stakeholder has in the system, including possibly the social media platforms. But I wanted to focus on the topic for today, which is how do you make social media platforms more responsible, right? Or possibly even liable. So we assume to begin with that their safe harbor is some kind of a cloak which can protect them against everything. That's not really so. Their cloak is a limited protection. It works only as long as they follow the rules of the game. And the rules of the game here is law of the land of India, which comprises the provisions of law as well as the rules framed thereunder. And the IT rules for intermediaries clearly mandates a lot of requirements in terms of due diligence, in terms of a notice for protection of victims and whatnot. The only thing that Shreya Singhal brought about a change in is it struck down Rule 3.4 partly to the extent that if the notice were to go from a user, then you know what you mentioned earlier, that the intermediary need not act upon. I want to change it slightly there to say that if an intermediary were to not act on a user's notice, they don't lose their shield. That is what Shreya Singhal said. It did not say that intermediaries do not have to act on a notice. The way it is postured, the way it is put actually changes the context. And the problem here is not of context. It also changes the way then an intermediary interprets it and applies it. If they had looked at it also in this way, right, that Shreya Singhal only said that irrespective of whether they act or otherwise, on a user's notice, their shield, safe harbor shield remains. That's it. Apart from that, there is nothing else which it impacted. It retained the rights of government authorities to issue notices and said that intermediaries necessarily have to act on it, and so do they have to in terms of an order of court. So you know that the recent fracas of government versus Twitter has been going on, and I have been very vocal on that also to say, you may very well question or contest the legality or constitutionality of any provision of law. You can also re-agitate and say that a finding of the Supreme Court is also inaccurate. That is how, if the court were to believe so, a larger bench is constituted and it evaluates what the outcome should be. You may do that, but to say that I will take law into my own hands and I will decide whether a notice is valid or not is not a leeway that Shreya Singhal is given. So look at the positives here. You do have a law, an armory of strong weapons. A victim is entitled to file a complaint, to bring it to the notice of social media platforms, and they have to act on it. Meaning they may not act on it, but then necessarily at some level there will be a consequence to it. To assume that there is no consequence, I think, is actually setting aside or ignoring all the other legal precepts over here. How and to what extent can they be held liable in terms of not acting despite getting knowledge of a criminal content on their platform is the one aspect which has not really been clarified in terms of even Shreya Singhal. Hopefully in Prajwala, this clarification will come through. The matter is still ongoing. And the reason why I've also brought in Prajwala is as follows. Let me tell you how many positives came out of it. The first was you got a very easy way to sit at home and file your complaint in terms of offenses against women and children, even before COVID. And that was when a portal was set up of cybercrime.gov.in. There is accountability and transparency in the process, which is mandated. Most importantly, to answer Shehla's point in terms of not sufficient taglines, at least with respect to a few of these in terms of child sexual abuse content online and of uploading of rape and gang rape videos of women online, there are now specific tags. It came after this committee and the order of court of October 2017. Then there is a proposal to deploy spider technology to see that content, once it is identified, will not be allowed to be uploaded again. So here is a remedy that will work even for revenge porn cases, right? And it also works backwards to ensure that if something similar had been uploaded from another source, that can also be taken down. Now, when you look at a lot of the consensus proposals which have become an order of court, and you fast forward to today, the first issue that I had just pointed out in terms of what was normally the narrative and what I had proposed, which was the use of artificial intelligence tools to identify content and to quarantine it so that only after human intervention it may be released for public viewing. Now that aspect became a non-consensus proposal and it still has to be decided by the court. But this was the proposal that also triggered the formulation of the government committee. Part of this in a way was accepted and it is a part of the order of the court, which is for development of AI tools for identifying content of a particular nature. Today, when you fast forward, you're already seeing AI tools being deployed for hate speech and fake news. A lot of it is text-based. So when you talk about use of technology to protect, can it or can it not be done always is a contentious issue. And here is what I would have to add as a positive note. It can be. At least the possibility of evaluating this process ought to be taken up. And when we take up these kind of tools, as a person who has always been very, very particular about free speech, I would myself want to bring in the cautionary note here that what we do should not become a slippery slope, that it will become a restraint on free speech. So we, when we talk about solutions, we look at the intermediary guidelines, we talk about everything across the board. You have only one law, but it is supposed to be applied for offenses against women and children, hate speech, fake news, terrorism, cyber warfare, right? So how do you and when do you delineate to what extent it should be applied in what manner of restraint, or not do so without impacting fundamental rights? So today where we are, one, yes, we do need new laws. There are so many developments from 2000 or even 2008 when the amendments were brought into the IT Act to today, or for that matter, even after Shreya Singhal to today, including Australia's laws. All these
Sorry
are
to interrupt you.
in mind.
Sorry to interrupt you, ma'am. If you could conclude in a minute, then I'll. Of course, we'll
Yes,
take
yes,
some
half
of
a
these
minute.
threads to other
Half a
panels.
minute.
Yeah.
Half a minute. So all these are anyway covered in my article, which will be uploaded shortly. So you can have a look at what the international trends are on this. That gives us an indication of how we can create delineations in dealing with offenses against women and children as a separate bucket, as opposed to all these other things we are now faced with. That way, we are not applying the same yardstick to everything, and we may possibly be able to avoid the slippery slope. I'm saying may possibly because one of the things you asked Sanjay ji about how well do law enforcement officers understand where we are going and all that, look at Shreya Singhal itself. It struck down unequivocally Section 66A. In 2018, PUCL had to move a PIL because law enforcement was still using 66A. And then the Supreme Court clarified, saying every district court in India and every police station should be informed that 66A is no longer law. And move forward to November 2020 or even 2021, it is still being applied.
Still being used.
Yes, it's still going strong, despite the fact that Shreya Singhal unequivocally struck it down.
I had to block it. I had to block it on my software here.
Yeah. So
that's the only way out.
Yes, we have abuse, we have a lot of issues, but there are very strong laws. You have a lot of substantive criminal provisions you can deploy when you have been a victim online. So please take recourse to law. Let's not get pessimistic in thinking, oh, the system never functions or works. Let's just self-censor ourselves. Let's trust the system because you never know. You may still have a 50-50 chance. And let's hope for a brighter future. On that note, over to you.
Thanks so much. And of course, you covered so many threads and legal and judicial developments. And thanks so much for that. And I think, of course, it's been a long-standing critique of the intermediary liability regime that it makes absolutely no difference between types of intermediaries, but also type of content that we're dealing with. So I think for the future, and especially since the IT ministry is considering amendments to the Act, I think that's a very useful pointer to keep in mind. I think what we'll do is step back and, of course, sort of again focus on and on the note of optimism, perhaps focus on solutions and recommendations. So I'll go to each panelist and I request you all to sort of limit your comments to 2 to 3 minutes each. What we'd love to hear is I know some of this has already been covered, but of course, if you'd like to add anything to that about what these platforms can do better. Of course, what we've heard till now, obviously, is they need to be more responsive in framing their community guidelines, in enforcement of their guidelines, making sure that they're available in different languages, especially for the Global South, in both in terms of algorithmic detection and sort of training their models over that, and human moderation. And the other aspect of the law, and we'll sort of move away from the criminal aspect that we've discussed a lot till now. What I'd love to also hear is whether the law can mandate some transparency and accountability mechanisms for platforms, right? Can the law say you be responsible to user platforms in a way without making them liable, so therefore not trampling on freedom of expression? Back to you, Shehla.
So while I was actually keenly listening to all the speakers, and thank you for your interventions, everyone. While listening to the last speaker, Nappinai, I wanted to make one point that the 2013 criminal law amendment, I don't think that we can discount the role of that or understate the role of the 2013 criminal law amendment in ensuring, of course, there is the cyber law, but at the same time, when it comes to implementation, it's oftentimes the CRPC that is, more important, and the procedural guidelines in law that are more important. I, as somebody who's had to face online problems of various sorts, would say that the 2013 criminal law amendment has been a real blessing. something that actually makes sure that law is implemented. Now, if I go as an activist and I file a complaint against a case of, say, communally motivated hate speech, etc., which is, which may have an overarching political angle, etc., it'll be very difficult to get that registered. But at the same time, if I as a woman approach a police station, and I'm speaking from experience, if I as a woman approach a police station and say that I'm being stalked, somebody is harassing me online, or this is not necessarily Twitter abuse of the garden variety sort that we are talking about here. We're talking about like stalking. I mean, like the way women have stalkers. So even in those cases, it's the 2013 criminal law amendment has made a huge difference because it ensures that the Thana actually registers your complaint. They can't not register your complaint. And when I think Mr. Sanjay Sahay was speaking, when you said that we've been doing gender sensitization for 30 years, and yes, at times it can seem frustrating. What does it all amount to, right? But it is I would say that the Justice Verma Committee and the 2013 Criminal Law Amendment has been the culmination of 30 years or whatever number of years of gender sensitization and women putting forth their points, feminists putting forth their theoretical points. Now, coming to what platforms can do better, Gushabat, I would be a very good panelist, and I will quickly sum this up. I think that there are two things to begin with that the platforms need to do. One is an interdisciplinary approach to this whole problem of hate speech. I mean, I think that it was either Rakesh ji or Sanjay ji who pointed out that the moderators, the content moderators, are very lowly paid employees, and you can't expect them to do an excellent job of moderating content. And I think that brings us to another problem, that the problem of content moderation and platform governance, etc., it should not be looked at purely as a tech problem. It is not a tech problem. I think that the platforms, to begin with, need to hear more from other disciplines, from human rights, from sociology, political science, etc., as to what constitutes hate speech, because it's not just a matter of vernacular versus English, which is something that I pointed out in the beginning, but it's also a matter of another kind of language, right? The technological framing of the hate speech question versus the, what should I say, sociological or social-legal framing of the hate speech question. I think that there needs to be a greater, and that's my second point, there needs to be, while defining what is hate speech, we have to understand that it's not just, I mean, hate speech has a very high threshold. As we as human rights activists, we don't want to insist on a very narrow, we do want to insist on a very narrow definition of hate speech, because we don't want to criminalize all forms of hate speech. So when we say hate speech, we mean a certain kind of, it's a technical term that we use, and we don't want it to include all forms of sarcasm and cartoons and rhetoric, etc. We don't want it to include that, all of that. However, what we need to understand, and what the platforms need to understand, is that hate speech does not exist in vacuum. It exists in a continuum, rather. And it is one thing enables another, one thing causes another, one thing leads to another. It's that kind of a thing. It's, it could be cartoons, it could be editorials using bigotry, right? Now, you can't necessarily criminalize bigotry unless it constitutes incitement of some sort, or unless it constitutes hate speech of some sort. But we have to have different mechanisms to address these different things. Now, we can't just say, okay, hate speech, we have IPC section 295, IPC section this, section 67 of the IT Act 66 is gone. So we can't just have that. There have to be different recourses or different responses to different kinds of things in the whole ecosystem of hate speech that enable it. And by that, what I mean is that if there's bigotry, that needs to be called out in a proportionate way. Right now, if somebody is, if there is a cartoon which amounts to further marginalization of a marginalized community, it could be countered using a variety of responses short of violence, short of threats to life of on the cartoonist. So there's that whole sort of fine line balancing that we have to do, because this can again become a slippery slope of another kind, right? Whether it's hate speech against marginalized communities or women. And I'm bringing in marginalized communities because hate speech against women also has these communal undertones. I mean, we know now for a fact that it is also qualified by community and marginalization and all that. So they need to be, the summary of my point is that there need to be different responses. What those could be, we could argue, we could debate over that. But there have to be, I mean, we can't just stop at saying, this is section 295, this deals with communal hate speech, and just forget about it. No, I think there have to be like a wide variety of responses that address this entire ecosystem that enables either hate speech against women or hate speech against marginalized communities. I think that the structure of the structure of hate is the same, whether we take the historical examples of the Holocaust, whether we take hate speech against women, whether we what's unfolding right in front of our eyes in India right now, this kind of normalization of hate speech, the structure of hate is the same. And I don't know if I made myself clear. Just to sum up, I mean that the 2013 criminal law amendment has been very helpful. And so platforms should also have more interdisciplinary approaches to defining hate speech and to addressing hate speech, because it's the theoretical perspectives, they play a huge part. In fact, in the feminist movement, the way women articulated their concerns and the feminist understandings of rape over 30 years, that contributed to the 2013 criminal law amendment. I'm sorry for making this very convoluted point. And the last thing that I said was that we need to have a host of responses to hate speech, and the platforms can begin by making a more sort of informed definition of hate speech.
Thanks so much, Shehla. And I think as someone approaching content regulation, also from a human rights perspective, I think it's always better to remain suspicious of criminal law and liability to, magically address all these problems. So again, I'll come back to Maheshwari ji. And again, what do you think should platforms do better, apart from, of course, what we've already discussed? And again, do you think the law can not insert criminal liability, but let's say, standards of accountability and transparency to the users in terms of takedowns, filtering, and of course responding to complaints from women, and as Shehla also pointed out, this is an intersectional problem. So of course, gender minorities, and in India, Dalit, Bahujan, Adivasis, who are also target of harassment and violence based on their identities.
Yeah. So once again, I mean, with respect.
And sorry, just before you start, I have made the mistake of not enforcing time well, so I will strictly
I'll not take longer this time. First of all, I mean, certain things which Nappinai ma'am conveyed with respect to certain improvements which have happened, I should say, because of the Prajula case hearing and the follow-up actions that happened. Cybercrime portal is a reality. To begin with, it was only restricted to certain kinds of cybercrimes, particularly related to CSAM, I should say, extreme pornography and rape, gang rape videos kind of things. But over a period of time, its scope has been enlarged. Very recently, they have started, Ministry of Home Affairs have already started empaneling cyber volunteers. The whole idea is that more and more unlawful content can be reported. So at least action can begin. Courtesy the same Prajula case, we had talked of platforms promoting trusted flagger kind of concept, that to reduce the burden on such moderators, if you can introduce such trusted flaggers, and at least I know, I mean, in YouTube, for example, there are 3 trusted flaggers as of today in India. And therefore, action on, I mean, as and when something is flagged by them, things go much faster. Now, with respect to the intermediary platforms, see, from our side, we have already initiated the move. Of course, now it's a bit old one. December 2018, when we initiated the move for the intermediary amendments. The work is in progress, and maybe, shortly they may, as well become a reality. The whole idea, therefore, is that, that was as a development of Prajula as well, that reporting has to be made easy, and reporting particularly of revenge porn content, particularly of violent contents, particularly of wherever there is a element of non-consensual obscenity being shown, somehow, one, the reporting should be made easy. Two, it should go beyond what Shreya Singhal has mentioned. And normally, of course, the platforms do cooperate, but then by law, we will expect them to be very, very responsive. We will also expect them to be maybe in terms of their response to be much faster, whether it is for providing information or maybe for taking unlawful contents. Grievance officer for larger platform has always been an issue, that they have been outside India. In fact, if I look at, Twitter India, for example, is different from Twitter Inc., or same is true with respect to Google or Facebook and all those things. So our expectation is that they open their offices here in India as Inc., and they, if they become available here, hopefully they will be much, much more accountable. They will be much, much more understanding of the context, the concerns. And to that extent, responsiveness will also increase. And I also believe that somewhere, down the line, we must be able to, have some sort of a identification of accounts, so that the fake accounts and the so-called anonymity, because anonymity also sometimes create a problem. It's not that I'm saying that, breach the privacy, but definitely if somebody is doing a heinous crime, should be traceable, the law should be able to take its own course. So these are some of the things which we had highlighted and which we are working on. And hopefully, if things materialize maybe very soon, hopefully you should be able to see the new intermediary rules 2021 now. Good. Thank you.
Thanks so much. And I think, again, perhaps, like as you mentioned all sort of the developments that happened in the 2018 rules. But again, this sort of asking of transparency and accountability of platforms, perhaps what we're discussing is that it should not only happen in criminal sort of terms, right? So, for instance, the law can mandate platforms to put out transparency reports of when they take down content and when they choose not to act on complaints of harassment and violence, right? And that is something.
So this is also an issue under consideration.
Okay. Thanks so much, and perhaps that is good news.
So as I said, this is also an issue under consideration. Yeah.
Perfect. So off to Sanjay Sahay for I will say that again. 2 minutes for comments. You seem to be on mute. Sorry.
See, what we have been doing all throughout is giving kid glove treatment to these intermediaries or platforms, whatever you call them. And first, you'll have to think of a situation as who is at the receiving end. And certainly, the platforms are not at the receiving end. So it is basically a battle between the courts, government, law, and the users, and all of them are a part of the Indian ecosystem. First and foremost, these people have to bring their offices right here in this country, and there has to be a registration of their Indian company. Same way as you have your KPMGs and PwCs and everything. So they basically have nothing to do with the law of the land of this particular country. And we are battling it out. I don't know of any of these platforms or intermediaries who have been penalized so far. The government has absolutely no idea, or nobody has an idea as to how their data cycle operates, what they do with the data, and what finally comes out of the data. So we have absolutely no idea where it's going, why it is going, and what is happening with it. The whole crux of the problem is that we are still giving the benefit of doubt, and that they are working with great, noble, motive or intention. So that is not the reality. And these things operate at the intersection of law, technology, and business. So until unless we bring the three together, and we don't understand, lawyers will talk from the law point of view. The technologists don't know what is happening in this platform. Governments with their governance overload, they are struggling wherever they are struggling. And if these companies have the capability to basically transact every single piece of data and monetize it in a manner to bring it to $500 billion and $1 trillion, if they intend to do whatever they are dictated to, they will. Otherwise, they will not bring down even Nancy Pelosi's video. They will, incumbent president, right or wrong. So his Twitter handle is disabled. So these people have become super states. Until unless we force them, nothing is going to happen. They will keep doing the lip service until unless they have to come to the law, the state, the sovereign power. So they have to report to the government, to the law. And we have to dictate. On the other way around, we are begging them, why you are not taking this down, why you are not taking that down. And in the same way as basically your compensation and penal and fine sort of affair was. So it is operating at that angle. So my first and foremost, the issue is that we have to dictate terms. We have to tell them what is technically feasible. Otherwise, they will keep giving us lots of all sorts of stories. And we have to set our standards, and they will have to abide by it, whether it is criminal or it is non-criminal. The data which emanates out of India, for whatever purposes, the country should control their data in whichever manner it wants. And it should not go and beg these intermediaries, who, I'm repeating again, have become super states. Rest, the other things are basically lip service. They have to exist, so they have to do their drama. Thank you.
Thanks, Sahay. Again, I think a sort of state-based approach that you're advocating for, of course.
Yes.
I think Nappinai, what do you have in mind about how can platforms be more responsible? And of course, I think, again, it's useful to highlight that some of the content that we're actually discussing here is maybe constitutionally protected also, right? And a feminist approach may not necessarily argue for its criminalization. So I think it's important to keep in mind when we discuss some of what the platforms can do better, because of course platforms are at liberty to regulate content in their own ways. So Nappinai, what do you think about others' recommendations, and what else? What other solutions do you have in mind?
So I'm just going to take from what Sanjay was mentioning earlier, and also what you just talked about. Platforms can regulate their own thing, right? Let me just sum up on this. One, it would be, lest people get the wrong impression from what Sanjay ji said about platforms not being amenable to the laws in India. He is only talking from the pessimistic side of how, enforcement has not possibly worked with them. But the law is very clear. They are very much amenable to the laws of the land in India, both civil and criminal. Whether they open their offices here or not is their choice. But to assume that merely because they haven't yet opened their offices here, they are not amenable to the law of the land is extremely fallacious and also a dangerous presumption to make. Okay, and incorrect, completely incorrect. They are completely amenable to the laws of the land here. And therefore, the last bit, what you mentioned, every corporation may have its own laws or provisions, not laws, rules or provisions or policies for their self-governance. But such internal rules cannot be against the law of the land, cannot be a defense against non-compliance with the laws of the land, will not even protect them an iota if there is a violation. So to claim that you have the right to decide how your platform will function, and that therefore by some stretch of imagination you believe that you are therefore not liable to comply with the law of the land, to which you have, through your own actions, extended your services to and have availed the benefits of, that you are not amenable to it, because you will decide whether you are amenable to it or not, or you will decide to what extent you want to be amenable to it and to what extent you will not be, is incorrect. So we need to have all these lines clearly drawn to understand where we stand today. We don't have to wait for the laws to change to hold intermediaries liable. I want to just close out with this favorite line of mine. I'm also a trained mediator who believes in the middle path, okay? But, and we always talk about the concept of samadhana, beda, danda. And I want to close my comment with this. We have and continue to use a lot of sama and dhana. Maybe now the time for Veda and Danda has come, right? So if you want to really make somebody responsible, if you tell somebody, "Arey beta, don't cross the road, a car will come and hit you," wait for your green light to go on for walking before you cross. The person may or may not listen. But if there is a liability to it, today we are seeing, if there is a liability to you not wearing the mask, you wear it. If it is just the fear that maybe you will contract COVID if you don't wear the mask, even at the risk of contracting COVID, you will still not comply with it. Because that is a remote risk, whereas a fine of even 200 rupees in Mumbai and 2000 in Delhi is an immediate risk. So there has to be a sanction. I mean, from Samadhana Vedadanda, I may be jumping to Adam Smith, but there has to be a sanction to a violation, and that sanction cannot be only on paper. It has to be implemented. So that's what I'm looking for. Effective enforcement mechanisms to be implemented to show that the laws work. When that happens, whether it is cyberbullying, whether it's stalking, whether it's revenge porn, or the child sexual abuse online, rape and gang rape videos being uploaded online, whatever, or for that matter, terrorism or whatever, will come down when there is fear that they can be caught. So we shouldn't be focusing on victims to tell them what they should do or should not do. Awareness is good for them, but that is not the solution. The solution will only lie where the criminals understand the consequences and face it. Over to you.
And we apply the same thing to the platforms also.
Absolutely.
They also face the heat and they also realize what they're doing.
Absolutely.
Yeah.
Thanks so much. And since we're a little bit crossing the schedule, what we'll do is head directly to Nandini, who of course is the respondent to this discussion. We'd love to hear your thoughts, Nandini. Over to you.
Thank you, Gushabad. I would like to begin by thanking all the panelists for their thought-provoking and rich reflections on a critical issue that bothers all of us today. And the issue is this: how can we prevent the platformized public sphere from becoming a digital Wild West where sexist hate speech has free reign? It's becoming evident to even those of us who are unfamiliar with the finer points of the law that social media platforms can no longer be seen as neutral intermediaries who are mere conduits of content. Their protocol or gatekeeping power to determine the content on the platform is becoming increasingly evident to us. And as was said in the panel, what this means is that many of the assumptions in the IT Act, when it was first framed about the neutrality of platforms, no longer holds today. And it is time to change our thinking about platforms. And we also are faced with indisputable evidence about how the social media business model thrives on the viral circulation of any content that grabs eyeballs. And as again said in the panel, what this means is that in a sexist society, gender-based hate only gets normalized because sexism is reinforced. And this leaves women users with this Hobson's choice of deciding whether to use those filters or technological options that limit their reach but protect them from hate speech, or compromise that the price they pay for the public presence is the hate they receive. And this is totally a very sad situation. There are also many reports that we have heard of how social media companies deliberately ignore internal studies about how algorithms that are trying to retain attention end up heightening divisive and polarizing content in user feeds. And where there is no business incentive for platforms to challenge the amplification of hateful content, they don't really act on this. And again, this came up in the panel where there was a conversation about how platforms do not attend to community standards and user complaints in non-English languages because it's not really like, material to their business interest. So I think it's very clearly time for us to shift the paradigm of online content governance by calling to attention the duty that platforms have towards ensuring a free and safe space for all. And building on the conversation today, it is equally clear that a feminist future for the internet lies in satisfactorily addressing the question, what is the role of platform intermediaries in the design and implementation of an ethics-based content governance framework that can actually promote women's public participation? I think it's evidently clear to all of us that protecting women's right to public participation is an integral element of protecting women's right to equality, and therefore clear norms and rules about what can circulate on social media and what cannot are essential for this purpose. And also, I think we must remind ourselves that an absolute case for unbounded freedom in the public sphere, both online and offline, comes with a huge cost. The self-censorship of women and also their social censorship, as was again mentioned in the panel. And therefore, I think as feminists, we just have to take the view that content that violates women's privacy, dignity, and bodily autonomy, content that is already considered unlawful by the duly enacted laws of the land, this cannot be allowed to circulate in the online public sphere. And now I come to my final point. What are the duties that we need to place on platform intermediaries in implementing such a content governance framework? From the discussions today, one thing is very clearly evident that there is certainly today in India an ambiguity about what the duties of platform intermediaries are in this regard, because Shreya's single judgment, despite its many gays, has created one problem. Though it does not actively prohibit platforms from responding to user notices, by not removing their safe harbor protection if they do not respond to user notices in a timely way, it doesn't really create any incentive for them to act promptly on user complaints. So this means that platforms can continue to practice this benign neglect and shrug off their legal obligations to respond to user complaints about unlawful content. And this is really a problem on our hands. I also think that this institution of a reporting and redress mechanism for speedy redress of user complaints, without this, platforms cannot retain their safe harbor. Something like this must be done, and this is a very urgent measure to fix platform responsibility. Also, as was mentioned in the panel today, we also need to be thinking of a very proper vertically differentiated intermediary liability regime, which can have a differential approach to dealing with manifestly unlawful content and infringing content. And we need proper rules and regulations in this regard. And the IT Act overhaul that is currently proposed, this is an opportunity for us to change the imagination of how we think of intermediary liability and think of when platforms can retain safe harbor and when they cannot, and fix the ambiguity about the duties of platform intermediary. And this is actually a time to act. And I would also like to make one final point that we have to understand that a normless public sphere, which is online, the normlessness cannot be inclusive or empowering for women. Clarity in the law about how platform intermediaries must respond to gender-based hate speech is essential, and this has to be founded in constitutional principles if we are to promote and create a gender-inclusive public sphere. And from every other context in the world, what research is showing us is that where there is robust binding regulation on the roles and responsibilities and the duties of platform intermediaries to act in this regard, like Germany, for instance, where platforms are heavily penalized with heavy fines if they do not act promptly, they have shown better results in terms of gender inclusive public sphere compared to other contexts which have just relied on self-regulation by platforms. So the time to act is now. And I think it's also time to think of like what to do so that responsibility is placed squarely and fully on the shoulders of platform intermediaries for the problems of the online public sphere. Thank you.
Thanks so much, Nandini. That was extremely well summarized. I'm so grateful for your inputs as well. And I think completely agree that, of course, the law can step into certain situations here in terms of demanding platform accountability. And we do have globally best practices to look forward to, especially in Europe, which has set very clear lines of how not to trample on free speech and therefore allowing certain nation states to operate and advance public accountability without trampling on rights. So I am very conscious of the time, and I apologize to all the participants whose questions could not be answered on chat. But this discussion was very, very informative and enlightening for me. So I hope it was for you as well. Of course, at the end, I'd like to thank IT for Change for organizing this great event. And I recommend everyone to visit the event website because there are just fascinating papers and that advocate for new approaches on how platforms can be governed with a feminist lens. So I really recommend that you read those when you get the time. And of course, lastly, thanks to all the panelists, Sanjay ji, Maheshwari ji, Nappinai ji, Shehla ji, and to Nandini for that excellent summary and for her inputs. So thanks so much for attending this.
Thank you.
And bye all. Have a nice evening.
Bye. Thank you.
Thank you to the audience. I also, I'm Anika from IT for Change, and I would like to also encourage you to register for the final webinar, same time next week. And in a very, very logical sequence from what should platforms do and what are the feminist frameworks of looking at that, we graduate to the next level of what should the law be doing and how should the law deal with misogyny. We again have a star array of speakers, deep thinkers, people who have worked and people who have grappled with this issue: Aarti Raghavan, Brinda Bhandari, Vaishali Bhagwat, Maria Salim, and we have Justice Gogne, Vishal Gogne, who is additional sessions judge, who will chair the session. And we hope to have a commentary from IT for Change from Bhavna. So kindly join in. I think this series has been very useful also to people from the feminist movement who are trying to understand this issue legally, technically, and otherwise. And I retain Nappinai's optimism that we should be able to, if we believe in a feminist world, we should be able to have one. So thank you so much. We are ending a couple of minutes early, but thanks all.
Thank you, everyone.